All right, if everybody is ready, we'll move on to the next case I had on my calendar. It was the state of Jersey versus James Levert Netters. He is here along with his attorney, Lawrence Lewis. The state is ready to proceed. We have ADA Puslak running the show on that. You may call your first witness, sir.
Judge, state will call Officer Montanard.
Yes, sir.
Investigator, can you please raise your right hand for me? And
well, it's kind of hard without your video on. Can you cut your video on for us, ma'am?
I work undercover, sir.
Oh, okay, well, that's fair enough. Then you can keep your video off for me.
Thank you.
And, I acknowledge that you have your right hand raised, and then I will let him begin the process.
It is raised.
Okay, you may proceed, Ms. Puslak.
do you swear or affirm that the testimony you're about to provide this court is the truth, the whole truth, nothing but the truth?
I swear.
Thank you. You can put your hand down now. And are you able to state your name for the record?
I'm
Investigator Montanard, it will be sufficient. Is that who you are?
Yes, sir. That's
Okay.
1790.
Okay.
And where are you employed?
I'm employed with the Gwinnett County Sheriff Office, sir. I am a member of the Human Trafficking and Child Exploitation Task Force, and I'm also a member of GBI's Internet Crime Against Children Task Force.
And are you a post-certified officer?
Yes, sir.
And are you familiar with the defendant, James Levert Netters?
Yes, sir.
And I'm going to read out 4 warrants. I don't believe I read them out a moment ago. 21W08647, 21W808648, 21W08649, and 21W08650. Are you the law enforcement officer that sought those warrants?
Yes, sir. I did.
Can you please describe for us the facts and circumstances that led to you doing so?
Well, on May 11th this year, Mr. Netters initiated a conversation with me as an undercover officer on an application called Plenty of Fish. Our conversation on Plenty of Fish was brief. On that same day, I sent Mr. Netters my number and I asked him to text me instead. And from that point on, our conversation moved through a county-issued recorded line. Shortly after Mr. Netters started to text me, I informed him that I was 14 years old, and Mr. Netters continued to talk to me. As the conversation continued, Netters asked me if I was ticklish and informed me that he would like to tickle me, as the act of tickling someone is something that aroused him. Mr. Netters further expressed interest in meeting with me, but stated that we'll have to keep our meeting in secret due to my age. Through the course of our conversation from May 11th to May 29th, Mr. Netters inquired multiple times about coming to see me. Mr. Netters was very adamant about coming to see me to tickle me. He had asked me questions like if I've ever role played before. And he further stated that he wanted me to act like a naughty schoolgirl when he comes to see me, and informed me that he would punish me by tickle torture. So when I informed Mr. Netters that I was nervous about him coming over to tickle me, he offered to pay me in order for me to let him come over and do that to me, which of course I refused. And I further expressed to Mr. Netters that his tickling obsession was weirding me out. So from that point on, Mr. Netters stopped talking to me, and he reinitiated conversation with me approximately 8 days later on June 7th. So on June 7th, Mr. Netters inquired about coming to see me on June 9th, and we ended up rescheduling for June 10th. When I asked Mr. Netters what he wanted to do when he comes to see me, he stated that he wanted to make me feel good, and further described that as licking my body, performing oral sex on me. Mr. Netters also described the inches of his penis. He stated that he hoped that I could handle it when he put his penis inside of me. And again, in June 11th, just kind of giving you guys a time frame, on June 11th, again, I rescheduled due to other work responsibilities with Mr. Netters. And Mr. Netters did confirm that he still wanted to engage in those sexual activities that he had described to me previously when he comes to see me. He also initiated more sexual conversations. He said that he would be pulling my clothes off, would be kissing me, bending me over again. He said that he would be putting his penis inside of me. And another time that we had to reschedule for June the 14th. And on that day, again, Mr. Nutters reiterated that he wanted to perform the acts that he had described. And then he sent me a picture displaying his penis and informed me that he wanted to show me his penis in person. So we ended up rescheduling again for June 15. Again, Mr. Netters was adamant about coming to engage in those activities that he had previously described. When I showed concern, when I told him I was concerned about being pregnant, Mr. Netters reassured me that I would not, and he told me that he would be using a condom to make sure that I did not. And finally, on June 15, I did end up setting up a meeting with Mr. Nutters at a prearranged location located in Gwinnett County, of course. Mr. Nutters informed me that he was getting dropped off by his cousin. I observed Mr. Nutters getting out of the car when he was dropped off. Mr. Nutters called me, letting me know that he had arrived. He described what he was wearing, and that is when Mr. Nutters was apprehended.
All right.
Thank you. Officer, were you present at the scene when Mr. Netters, when Mr. Netters was arrested?
Yes, sir, I was.
Okay, so are you able to identify him today on any of the screens that you can see?
Yes, sir. Mr. Netters is sitting next to his attorney and jail court video.
Thank you. I don't know how well you're able to see, but are you able to see what color jumpsuit he's wearing?
Green. I could see him wearing a green top. I can't not see what he's wearing in the bottom.
Thank you. And everything, let me ask you this. So these conversations that you had with him via text, were all of those done through that app that you referred to?
Say that again, sir?
The conversations that you had with him, were all of them through that application, that phone app that you talked about?
No, it was not. My conversation with Mr. Netters on that application, Plenty of Fish, was brief. And that same day, I provided Mr. Netters with my number, and he started to text me. So all the sexual conversation that Mr. Netters initiated took place on a county issue recorded line, where all text messages, videos, not videos, all text messages, voice conversations are recorded.
So you still have a record of those conversations?
Yes, sir.
And let me ask you, you may have said this already, but when Mr. Netters was apprehended, did he have anything noteworthy on his person?
Yes, when Mr. Netters was apprehended, upon the officers conducting an incident to arrest search, Netters did in fact have a condom on his persons, which go in line with the conversation that he has had with me by telling me that he would be using a condom in order to ensure that I did not get pregnant.
Okay. Has Mr. Netters made any statements to you since he's been arrested?
Mr. Netters was interviewed after transported to the Gwinnett County Jail. I did not conduct the interview. Another investigator did, and in the interview, Mr. Netter did admit that he knew that I was 14 years old, but stated that I looked older and sounded older. Hence, he was willing to show up in order to see if I was in fact 14.
And did you ever tell him that you were any age other than 14?
No, sir.
And you did in fact tell him that you were 14?
Yes, I told him that I was 14, and he acknowledged it.
And did all of this occur in Gwinnett County?
Yes, sir.
Thank you. I believe those are the questions I have for you right now, at least.
Thank you.
May I, Judge?
Yes, sir.
Thank you. Investigator Montanard, my client was arrested on June 15th, is that right?
Yes, sir.
Okay, June 15th. And the conversation, when you first communicated with him on Plenty of Fish, did that happen on May 11th?
Yes, sir.
Okay. So the dates in the warrant indicate basically first contact on Plenty of Fish to the date of arrest. Is that right on the warrants?
Yes, sir.
Okay, got it. The age requirement on Plenty of Fish, is that 18 years old?
Yes, sir.
Okay, so my client meets you on Plenty of Fish, and if I understood your testimony correctly, you redirected that conversation offline to the Gwinnett County telephone, cell phone. Is that right?
Yes, sir.
Okay. My client is texting and talking to you in between May 11th and June 15th. Is that right?
Yes, sir.
Okay. And I was paying attention as best I could, and I do understand that there were a number of times that things were rescheduled. Can you tell me in between May 11th and June 15th how many verbal conversations you had with my client?
Verbal conversation.
Yes.
I could-
More
I
than
could-
10, less than 10?
I could not tell you that right this second, as I don't have my verbal communication with your client open.
Okay, that's fine. Let me ask you this question. Do you recall how many, I'm gonna call them text streams, texting where you and him would text back and forth for a period of time? Do you recall how many times that happened?
I can't really give you a number, but it was a lot of conversation, as it was over a month of conversation between May 11th and June 15th.
Okay, and was it the type of conversation where we would text back and forth for maybe 30 minutes and then another day or two would go by, or is it this sort of like you text me, I text you, you text me over a course of 2 or 3 hours? Do you recall?
It was a mixture of all that you've described.
All right, and it sounds like the longest period of time where you were not texting or talking to my client between May 11th and June 15th was this 8 days where there was a sort of gap in communication. Is that fair to say?
I would say that would be fair to say, yes.
Okay, so you're talking with him typically every day or every 2 or 3 days. This 8 days later that you testified to was the largest period of time where you did not communicate. Is that fair to say?
I believe that would be correct, but I'll have
Okay.
to go back to my record to ensure that that was the longest time, but I believe that is
Yeah, that's
correct.
fine. And listen, all of these conversations are recorded and the texts are recorded. So if there was a 9-day period, it will be in the recordings anyway. Is that fair to say?
Correct.
Yeah, the gap would be in the recording. So let me ask you this question. Did you send him any photos? I know you indicated he sent you photos. Did you send him photos?
Yes, I sent Mr. Netters a photo.
Okay, and when you say you sent him a photo, was that the early part of May or the sort of closer to the June 15th date?
I would have to pull up my record to be able to tell you exactly when I sent that picture, sir.
Okay, do you have access to that like within a minute? I don't want to unnecessarily create any delay.
I am trying to get to it as we speak.
Okay.
So if you could continue with your questions, when I do
Okay.
find it, we could go back to it.
Okay, all right, good. When you sent him that photo, you indicated that you sent one photo and you're trying to find when you sent the photo.
I
Was
believe I only sent one picture to Mr.
Okay.
Netters.
Was that photo somehow digitally altered?
Yes, it was. It was digitally altered to make me appear to look younger, yes.
Okay, and you indicated that he sent you at least one. Did he send you one or more than one photo?
Mr. Netters sent me multiple photos, including a picture of his penis.
Okay, and in the picture of his penis, do you see his face or do you just see, I'm gonna say, a penis? I've seen enough downloads on phones to know sometimes I can't understand why, but males have different penis photos in there. Could you see his face in the penis photo that he sent you?
No, it was just a picture of a penis. I could not see his face. However,
Okay.
Mr. Netters did tell me that he wanted to show it to me in person.
I mean, it's sort of immaterial whether it's his penis or somebody else's penis. You can't send a photo of a penis to a 14-year-old. I'm just trying to figure out if you saw his face. Were you able to tell when you sent the digitally altered photo?
Yes, it was the same day that we started talking, which was May 11th.
May 11th. Okay, all right. And his interview, it was recorded, is that right?
His interview, yes, sir.
Thank you very much. No further questions.
All right. State have any further questions of this witness?
I don't, Judge.
All right. State have any further evidence?
No, sir.
All right. I'll turn to the defense. Mr. Lewis, y'all have any evidence to present?
Judge, I don't have any evidence, and I really only have an argument as to, I'm gonna call it either 647 or 648 because I think it's duplicitous? Duplicative. That's the word. Duplicative, right. Obviously, the obscene internet contact with a child is the forwarding of the penis, whether it's his or just a penis pic, doesn't matter.
Right.
Use of computer services to seduce or solicit, I got that. It's really this criminal attempt to commit a felony. Obviously, he could be charged with 10 of those.
Mm-hmm.
One for tickling, one for this, one for that, one for this, but it all goes to the same conduct of really getting in the car, performing the act of driving over there. So it really doesn't matter what the conversations were beforehand. The criminal attempt involves him getting in a car with condoms and driving over to a person that he believes is 14 years of age. The act of
Well,
getting...
I tend to agree with you, but I'm going to give Mr. Hulslack the opportunity to respond to that argument. Warrants, I'm looking at warrants 647 and 648 myself, Mr. Hulslack, and give you an opportunity to tell me what your position is to whether they're duplicative and going forward on just one.
Thank you, Judge. So I do think that the only distinguishing factor that I can see, and Mr. Lewis, you can correct me if I'm wrong, is that essentially the underlying felony is child molestation versus aggravated child molestation. I am taking a look at the statutes right now. See what the distinction is between the two.
Well, I think it's the act, Judge. I think that the issue is the act being engaged in sexual acts versus engaging in an act of sodomy, which comes from the conversation online.
Right.
His driving over there, once he drives over there, every act that he described can then be a criminal attempt to commit. That's really my argument. I think his driving over there doesn't create 50 criminal attempts. I think it really just creates one.
Yeah, because it's the one driving act.
It's the one driving, right?
Yeah.
Well, but it's not so much just the driving act, it's what the intended felony was based on that act. So I do think same conduct can support multiple charges. I'm just looking specifically where one's child molestation and the other is aggravated child molestation. If the court's inclined to only bind over one of these, I would ask the court to bind over warrants 21W08648.
No problem. I'll do that. You want to pick
And then
that
my
up?
understanding is there was no dispute to the remaining two warrants. Am I correct about that?
That's correct, Judge. That's correct.
Yep. All right, gentlemen, based on the evidence I heard here, I do find this enough to bind over 3 out of the 4 warrants, so I will bind them over to Superior Court. The only warrant that I won't bind over will be, as I find it is duplicative, will be warrant number 21W-08647, which is the criminal attempt to commit a felony with the underlying offense being child molestation in that one.
Judge, are you in a position to hear bond?
I am, because my understanding it is a criminal attempt, not an actual aggravated child molestation.
That's what I thought. I just wanted to make sure. If I maybe heard on the issue of bond, I'm assuming the prosecutor's objecting to bond?
I would object to a bond, Judge.
Yes.
Okay, good. I'm going to just swear my client in very briefly. Judge, raise your right hand, Mr. Netters. Do you swear from the testimony provided this afternoon in the case of State of Georgia versus James Netters will be the truth, the whole truth, and nothing but the truth, lovely God? Okay, I'm going to direct you speaking to the mic. Typically, the mic can't pick up both of us. It's more important the judge hear you than it is he hear me. What is your full name? How far have you gone to school, Mr. Netters? 12. Okay, you gotta speak up loud enough. Pretend you're shouting at the judge there. He's gotta I can hear you clearly, but I gotta make sure he can hear you. Before you were arrested in June of 2021, where were you working?
I was employed at Applebee's full time.
Okay, how long have you been working at Applebee's?
3 years.
Would you be able to return to that job if in fact you were able to do the bar?
Yes, sir.
Prior to June 2021, when you were arrested, where were you living?
240 Mary Drive.
Mary Drive?
Merritt.
Mary
Merritt
Drive.
Drive.
Who else is there?
Just my brother and my cousin.
Okay, so it was a brother or something, is that right?
Yes.
You just said, and Judge Rankin is probably going to say that you are not allowed to be on any sort of social media websites. You understand that?
Definitely correct.
Dating sites, Facebook, Instagram, you do all of that.
Yes,
All
sir.
of that if you're going to and that.
Yes, sir.
I intended to ask the judge for a bond amount of $20,000. That would probably require about $2,200 to a bond. But you think with your son's help and your cousin's help, you might be able to make the bond?
I've actually spoken with my mother on this part, and she said that whatever type of bond that I get, that she'll be able to pay for that.
Okay, where is your mother?
She's in Wisconsin.
Okay, judge has some concerns. Judge is inclined to set a $50,000 bond. Your mother indicated that she would help you make that bond. Is that right?
Yes.
What type of work does your mother do?
She's a psychiatrist.
All right, good. Are there any children that reside at the residence where you were residing at one Merit?
No.
Okay, good. The prosecutor, he may have some questions for you.
Before you ask any questions, if you're inclined, Mr. Hulsack, can you give me his criminal history, please?
Yes, Judge. So I am showing no offenses out of the state of Georgia, or at least none that I think the court needs to consider. There was a license offense from 2021. However, I am showing some other offenses that are noteworthy. There is a federal conviction for fraud from 2006, and that related to that conviction, I'm also showing convictions for violating probation and then for violating the terms of a conditional release. There is, and like I said, that is a federal crime. There's also an out-of-state criminal history where I'm showing a 2002 failure to appear after admission for bail. And then there are several other serious charges on that history that I'm not particularly clear on whether or not there were dispositions. So I can tell the court about those charges if you'd like, but like I said, I cannot speak to what the actual dispositions of those cases were.
All right. Very good. Do you have any questions for him before I make a decision?
No, sir, I don't have any questions for him.
I assume the state's position is that you are against bond, sir?
Yes, sir. I think that if released on bond, he presents a risk to commit additional felonies, a danger to the community, and potentially even a flight risk. And the reason I'm basing that, my basis for that is both the charges and the facts that we've heard from the investigator, as well as what we've seen on the criminal history. Because as I indicated, he has a history of violating probation, violating the terms of a conditional release, and a failure to appear after being given bonds. Also, you heard the facts of the case from the investigator. While this was a case based on an undercover officer, the behavior that Mr. Netters has shown indicates that if released on bond, I do believe he is a danger to the community. He has the potential to engage in this behavior again, and the next time it might be an actual child and not just an investigating officer who's undercover. And I'm concerned that if released on bond, he has the potential to harm a child, to harm a minor of some sort, and thus presents a danger to the community as well as a danger to commit new felonies.
I'm going to deny bond in this case based on the fact that I find the defendant is a risk and danger to the community, as well as a flight risk in this case. So bond is denied. He's with the sheriff.
Thank you, Judge.